Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamblett Kerrigan, and in this vlog I'm going to be talking about breaches of fiduciary duties in relation to trusts, both New Hampshire or Massachusetts trusts. Trusts are used commonly for estate planning tools or other reasons, particularly in regards to the standard one is you create a will and you do a trust, and it's called a revocable trust, but then becomes irrevocable after your death. There are also trusts that are established for Medicaid planning that I'm really not going to be discussing in this, but the breach of fiduciary duty is what I'm going to be focusing in on today. Because sometimes what you have somebody that creates the trust and they perhaps have one of their children act as a fiduciary for the other child, or they have a neighbor act for a fiduciary for the other child, and they think that that person's going to carry out those obligations, and I'm going to be talking about what happens when they don't. And I'm also going to be talking about in this blog about how to avoid, if you are the trustee, from having a viable claim, a claim from the other person that sticks in court in regards to your breach of fiduciary duties. One of the first things you want to do if you're a trustee of a trust is you want to make sure that you are administering the trust in accordance with the trust document. Read the trust carefully and see what the intent is. If you have any questions, you should talk to an attorney in regards to that. We want to find out what the intention of the grantor was. In a regular trust, maybe it's a situation where they're specifically spelling out that they don't want a distribution being made to a particular beneficiary until they reach a certain age, and there's some discretionary distributions are made for education and the like. Think about what the grantor wanted and think specifically about the express terms of the trust and follow those terms. They're very important to follow because that's going to be the cornerstone of what the court's looking at if there's a claim against you for breach of fiduciary duty. Second thing is, if you have discretion, you're going to want to consider the next step of what I'm talking about is duty of loyalty. You have a duty of loyalty to the beneficiaries of the trust. That doesn't mean that you have to do whatever they tell you to do because the grantor gave you instructions of what to do, and that's the whole reason for the trust. But it doesn't mean that you get into your situation, you get into dealing with your own petty problems that you had with your sibling when they were always mom's favorite, and now you have some power and you're going to show them what it's like. You're breaching your fiduciary duty in that situation if you're taking actions to get back at your sibling and you're abusing your power as a fiduciary to get back to them. Or you're self-dealing. If you're in a situation generally as a trustee, you're not allowed to self-deal. Now in a practical circumstance, if you're acting and you're taking some advantage of a situation, but some other professional would have to do it. If you were a professional, say you were providing accounting services, or you're actually a lawyer and you're doing and I would avoid that for conflict of interest issues, but if you were to do other legal conflict of interest issues, but if you're doing some services, maybe you're a broker, maybe you're doing property management and you have a property management service before, if you're charging a reasonable fee, the beneficiaries, even if they challenge it in court, there's going to be a problem. There's going to be a problem with proving that there's damage to them because of your breach of fiduciary duty. So, and if you really are doing something better than some other property management company is doing, you're not breaching your duty of loyalty, and the beneficiaries can't likewise, just because they want to get back at you, convince a court or a judge to take action against you. So in those situations, you definitely don't want to self-deal. You don't want to get back at your beneficiary people. If you're treating yourself better than if you're one of the beneficiaries and you're getting yourself a better deal because you're a fiduciary and you're saying, well, I'm the one in control of this, so I can make some decisions, I can make some discretion to my favor, you're going to probably have problems in court, both in Massachusetts and New Hampshire. You have problems going to court and saying that I used my fiduciary powers to get back at my sibling or to take a better half or third or quarter interest that I was going to get in the trust because I was able to exercise my fiduciary duties to take advantage of that situation. Courts don't like that, and also there's a trust code, and you can get attorney's fees rendered against you personally if you're acting in a breach of fiduciary duty, so don't do that. One of the things you also want to deal with when you're dealing with this is, it should be obvious, but if there's trust monies or assets, don't commingle them with your own assets. Don't take the monies from a trust and use it put it into your own operating account. You want to keep very clear, accurate records, specifically records. And if you're going into court and saying you put it into your own account and here's your accounting, the court's going to be very frustrated with you, and that's not the good way to start if there's a damage claim against you where the court's already thinking that you're fast and loose with the trust assets. So always keep them separate, keep a proper accounting, make sure you account for every single dime that's in the trust. Don't use the trust to get back at your fellow fiduciary or your fellow beneficiaries. Don't use the trust to self-deal and make yourself get a better distribution than would otherwise happen, or get you professional fees or other fees that you would not otherwise be entitled to, unless you can actually show that those fees would have had to have been incurred by somebody else, and you're maybe doing better deal on that circumstance. So I'm Attorney Dan Marr. I've been dealing with this for 36 years, and I've been practicing both in New Hampshire and Massachusetts, licensed in both and practiced in both. I can be reached at 603-883-5501, 603-883-5501. You can check out my weekly vlogs by checking out our firm website of NashuaLaw.com. Check out my bio and click the blog, and then by topic you can decide if there's any other vlogs that are about the same time minutes, and there are a variety of different topics that a lot of my clients find are useful. So I hope to work with you if the opportunity arises. I'm Dan Marr, 603-883-5501. Thank you.